Where did the Supreme Court go wrong when it comes to the 11th Amendment? Because the 11th Amendment is a crock of shit. It's a crock of shit. It's saying that if Tennessee injures me, I can't sue Tennessee. So it doesn't make any sense whatsoever. Hans v. Louisiana. Excuse me. 1890 Supreme Court case. This is, the Supreme Court interpreted the 11th Amendment immunity broadly to prohibit suits against a state, not only by citizens of another state, but by a state's own citizens, and in cases arising under federal law. This means if the state of Colorado injures me, I'm not allowed to sue the state of Colorado. The 11th Amendment does not prohibit citizens from suing their own states, but the Supreme Court has expanded the 11th Amendment to say that it couldn't, and they fucked up in Hans v. Louisiana. So this is 1890, had been the earliest case when it actually had, kind of turned the shit, Cohen's. You had the Cohen's decision, which, interpreted it correctly, and then 1890 overdoes the Cohen decision. So the Hans court placed weight on the speed on which the amendment was adopted, suggested that Chisholm had erred in upholding jurisdiction under the original Constitution, and they're saying that they couldn't have even have contemplated individual suits against states back in those times, back in those days. What, a regular citizen suing a state? That doesn't even, they couldn't even have thought of it. That thought couldn't have even have been fathomed. A private citizen suing a state? What? Where is this even coming from? Yeah, they're talking about the three branches of government. They're talking about so many distinctions, but they never thought about a private citizen suing the, individual state. Yeah, I'm sure that was an idea that was floated by the stream of conscious genius minds. I'm sure that idea came across. Anyways, that's ridiculous. So Hans v. Louisiana is when the 11th Amendment goes south. So now we're interpreting that the states have sovereign immunity. So therefore, citizens can't sue other states or your own states, or no citizens can sue the states. The states are just, above everybody. They got immunity, sovereign immunity, state immunity, so they have, they can do whatever the fuck they want to do without any repercussions whatsoever. You're going to have the Seminole Tribe v. Florida, 1996 decision. You're also going to have a 1999 dissent, well, actually a decision. I wrote the dissent down, but Alden v. Maine, so 1999. This is a bad decision by the Supreme Court. Seminole Tribe v. Florida, 1996, also a bad decision by the Supreme Court. In the Seminole Tribe v. Florida, 1996, the Supreme Court ruled that Congress didn't have the power to sue states under its Commerce Clause powers. The court issued a majority opinion for 5 justices, holding that Congress lacked power to subject states to suit when it legislated under its Article I Commerce Clause power. Since Seminole Tribe, the court has reaffirmed this holding and, for the most part, has limited Congress's ability to subject states to suit in federal court unless Congress acts pursuant to its powers to enforce the 14th Amendment, in part on the theory that it was adopted after the 11th Amendment or for some bankruptcy issues. So if it's not about bankruptcy, if it's not about the 14th Amendment, then you cannot sue the state. The federal courts can't sue the states. States can't sue the states. In the late 1990s, the Rehnquist Court issued a series of decisions which reinforced state immunity from suit under the 11th Amendment. And it started out with the Seminole Tribe v. Florida. So that's interesting. So did they fuck over the Seminole Tribe? Is that what happened? The Seminole Tribe got fucked over? I would like to, look into more details. But essentially they're saying that the Commerce Clause powers that Congress has under Article I, they couldn't enforce, they couldn't use those powers. Congress, right, the reason why they're in Article I is because the legislature was the strongest branch of the 3 branches. And now they're sitting there saying that the Commerce Clause of the legislature, they can't force the judicial branch to listen to their cases. So Alden v. Maine, 1999. This is a bad decision too. So the Alden decision, I want to read a dissent from it to then get into the case, but it's about probation officers from the state of Maine. They weren't getting paid for their overtime work, and under the Fair Labor Standards Act, they were supposed to get paid for their overtime work, so they filed a case in the federal courts. So this is the employees, this is the citizens of Maine suing the state of Maine because the state of Maine was their employer. So this is going to be Alden v. Maine. Alden v. Maine. So he's suing his own state, and they're going to say that the 11th Amendment says, nope, they have sovereign immunity. Nope, 11th Amendment says they got sovereign immunity, so we're just going to go with the sovereign immunity. So therefore, the probation officers are going to not get paid. So that's clearly incorrect, right? So the dissent, Justice David Souter, writing for a four-justice dissent in Alden, said the states surrendered their sovereign immunity when they ratified the Constitution. Then he says that he reads the amendment's text as reflecting a narrow form of a sovereign immunity that limited only the diversity jurisdiction of the federal courts. He concluded that neither the 11th Amendment in particular nor the Constitution in general insulates the states from suits by individuals. He's absolutely right. So that's 1999. David Souter at least knew what the fuck was going on. So the Alden decision, probation officers, right, they're getting paid. They're not getting paid for their overtime work. Maine, the state of Maine, isn't giving them the pay that they're supposed to have if we're going to pretend that federal law means anything. So the Fair Labor Standards Act, that's the federal statute that's in question. So the probation officers, so these are police officers, right, the probation officers, the ones that are tracking the people on probation, they sue the state of Maine because they said they weren't getting paid for overtime, according to the Fair Labor Standards Act, the FLSA. So this federal statute, they're going to go to federal court to enforce this federal statute, and they're going to say, well, the federal statute and the federal court, you're not allowed to even come into this court to get this enforced because of the 11th Amendment, the sovereignty immunity, the 11th Amendment immunity, sovereign immunity bullshit. The 11th Amendment is a crock of shit. It is a crock of shit. So does that mean the states could just ignore the Fair Labor Standards Act, or they're supposed to pick some other path? Well, you didn't do the right crazy jurisdictional path, so I mean, the Fair Labor Standards Act is pretty important. So how can the federal government enforce their federal statutes if the states just outright reject it? Can they get the courts? I mean, what can the federal government actually do? It really seems like the Supreme Court is shackling all governments because they want to maintain this bullshit notion of sovereign immunity. Just because, back in the day, fucking England, they had sovereign immunity and shit. Fuck sovereign immunity. Nobody has sovereign immunity. We're all under the rule of law in a democracy. If the state is injuring people, the state should get in trouble for it. So that's pretty clear cut and dry, I think. 1992 is when the probation officers employed by the state of Maine filed a suit against their employer in the United States District Court for the District of Maine. The probation officers alleged violations of the overtime provisions laid out in the Fair Labor Standards Act. And then, after the dismissal, the probation officers filed the same action in Maine state court, so they go ahead, dismissed it, saying that the 11th Amendment to the United States Constitution gives the states sovereign immunity, so they dismissed it, then it goes back in court, comes back, goes appealed in the Maine appellate courts, and then it goes to the Supreme Court of the United States. In a 5-4 ruling, the court concluded that Article 1 of the U.S. Constitution does not provide Congress the ability to subject non-consenting states to private suits for damages in its own courts. In addition, the court held that Maine was not a consenting party in the suit, and therefore the ruling of the Supreme Court of Maine was upheld. Writing for the court, Justice Anthony Kennedy stated that the United States Constitution provides immunity for non-consenting states from suits filed by citizens of that state or citizens of any other state, noting that such immunity is often referred to as the 11th Amendment immunity. Such immunity, the court continued, is necessary to maintain the state sovereignty that lies at the heart of federalism. However, according to Alden v. Maine, sovereign immunity derives not from the 11th Amendment, but from the federal structure of the original Constitution itself. Oh, my God. So somehow they're actually saying that the whole point of sovereign immunity was there to begin with. It wasn't this 11th Amendment stretching of the 11th Amendment. No, it was in the original Constitution. Yeah, tell me which clause. Tell me which article, which clause. I would love to know where it says that states have sovereign immunity. There's a couple of exceptions. The 14th Amendment exception, so that's across the board. Citizens can't sue the state. They can't sue other states. They can't sue their own state. They have sovereign immunity. So the only times when the federal government can sue the state governments is for some specific federal things. So the bankruptcy laws, the 14th Amendment. There's also the Superfund. There's like specific statutes that somehow they have been able to get past the 11th Amendment immunity block. Let's see, there is a Disabilities Act. The Disabilities Act, not the Fair Labor Standards Act, right? No, you can go ahead and ignore that, states. They can't sue you for that. But when it comes to the Superfund, the Disability Act, the bankruptcy laws, and the 14th Amendment, those are all exceptions that the federal courts could sue the state courts. So they don't have complete immunity, right? They don't have complete sovereign immunity, but they have pretty much near absolute with only a few exemptions. So the suitor, okay, so he dissents, right? Here's a longer explanation. He said that the concept of sovereign immunity had been misapplied by the majority. So he didn't believe Alden v. Maine was correct, 1999. David Souter continued by noting that the idea of sovereign immunity was unclear during the period of the Constitution's ratification. In addition, he argued the framers would certainly have not expected the idea to remain static over numerous years. In addition, Souter argued that the Fair Labor Standards Act was national in scope and, as a result, did not violate the principle of federalism as argued by the majority. Souter also argued that the claim that the Fair Labor Standards Act was unconstitutional was spurious. Such thinking, he argued, could only be reached based upon the misguided notion of sovereign immunity and notion of federalism the majority had used in reaching its decision. Man, the Supreme Court in 1999, it all started with Hans, right? The damn Hans decision, Hans v. Louisiana, they fucked it up in 1890. They had it right in 1821 with the Cohens v. Virginia decision, but then just 70 years later, Hans v. Louisiana overturns the Cohens decision, so where's the stare decisis on that, right? Yeah, I'm sure they didn't follow shit. They overturned it. And then ever since then, Hans v. Louisiana has been the law of the land. And then they extended it, and now it's turned into this big-ass monster. At no point in time does the 11th Amendment nor does the Constitution grant any sovereign immunity to anybody. They're inferring shit that's not there. And, did they want it? Did they not want it? I bet you could find founders that wanted it, and you could find founders that didn't want it. That's why they didn't put it in there. They gave it to us to decide. And we haven't really decided. We're just letting the courts play all these stupid, fucking legal games, and they're not coming down with anything concrete. So when it comes to the 14th Amendment, there's a City of Borney v. Flores, 1997. Something about the federal interest or when Congress enacts appropriate legislation to enforce the 14th Amendment, I think Section 5. They also said something. It's Fitzpatrick v. Bitzer, 1976. So the 14th Amendment exemption, you want to read more about it, check out Fitzpatrick v. Bitzer, 1976, because that's where it says Congress can break state sovereign immunity when it goes through the 14th Amendment in order to enforce the Bill of Rights. So Justice Souter, he was right. His dissent is right, so that's also for more research. He's got a better understanding of what the majority of the court. It was only a 5-4 split, so it's just by one vote. Just one vote is why sovereign immunity was kept in 1999, Alden v. Maine. But sometimes you get these badass dissents. So I think the dissent, David Souter's dissent of that case, you could really learn a lot, because he was right. He was 100% right with everything I've read so far. There's also just some sort of principle, some guy named Blackstone. He said it's a general indisputable rule that where there's a legal right, So the right to free speech, there's also a legal remedy by suit or action at law whenever that right is invaded. So you can sue them or you can call the police. So you abridge my right to free speech, I can sue you, or I can file criminal charges. There has to be some kind of remedy. You took away my right to free speech. In order for that right to be enforced, something has to happen. Something must happen. People can't take away your free speech, and then they just get to walk on by as if, they did something that was legal. They did something illegal. Chief Justice Marshall asked about Marbury. He says, if he has a right and that right has been violated, do the laws of his country afford him a remedy? If he has a right to free speech and that right has been violated, then do the laws allow him to get some kind of remedy? Of course. So it's a rhetorical question, but essentially that's Marbury v. Madison, 1803 case, and then Blackstone said it. So where there's a right, there's a remedy. So sometimes a citizen from Texas may need to sue New York State for some shit New York State did to that Texan. And that obviously seems like an option that ought to be a possibility for a citizen to find a remedy for their abrogated rights. Where there's a right, there must be a remedy. Now there's some incredible Supreme Court cases that are getting us back on track. So we're having the 14th Amendment exemption, Fitzpatrick v. Bitzer, 1976. We have Ex parte Young, a 1908 case, a 1989 case, Pennsylvania v. Union Gas Company. The Superfund Act, somehow the federal government were able to enforce the Superfund Act under the Interstate Commerce Clause. So the Superfund Act enacted under Congress's Article I power to regulate interstate commerce. They didn't have an opinion about it, but this is the federal government forcing the state government to abide by the Superfund Act. And so they broke sovereign immunity for the Superfund. So therefore there's a Superfund exemption, 14th Amendment exemption. There's the federal court's removal jurisdiction exemption. This is more of a complicated one, but the Lapides v. Board of Regents of University System of Georgia, GA, if you want to check that out. But it says something about the Supreme Court ruled that when a state invokes a federal court's removal jurisdiction, it waives the 11th Amendment in the removed case. So, okay. Bankruptcy exemption to Central Virginia Community College v. Katz, 2006, the court ruled that Congress could do the same regarding bankruptcy cases by way of Article I, Section 8, Clause 4 of the Constitution. Central Virginia Community College v. Katz, 2006, the court would narrow the scope of its previous sovereign immunity rulings and hold that Congress could use the bankruptcy clause of Article I, Section 8, Clause 8 to abrogate state sovereign immunity. So for bankruptcy reasons, for 14th Amendment reasons, for the Superfund, for the federal court's removal jurisdiction, for some other things too that I've mentioned prior to just now. So Ex parte Young, 1908. This, you can't sue the state itself, but you can sue the state officials. So that's interesting. The state is just a social construction which is made up of people and buildings. So we're going to give the state complete immunity, but not the state officials. You can sue the state officials directly. So what a dumb... This is just some legal juggling, Supreme Court ruled that federal courts may enjoin state officials from violating federal law. Ex parte Young, 1908, determined that a citizen could sue a state official to prevent that official from carrying out a state policy that was deemed unconstitutional. In a 1993 ruling, 1993, Martin v. Voinovich, the High Court ordered the governor of Ohio to construct housing for handicapped people to comply with the Americans with Disabilities Act. So there's an exemption to enforce Americans with Disabilities Act, to enforce the Superfund Act, to enforce bankruptcy laws, 14th Amendment laws. You're allowed to sue the state. The federal government can sue the state. So the federal government's given them a few exceptions to their rule of strict state sovereign immunity. And so Yeah, that's essentially all of everything that I need to talk about. The conclusion, essentially, okay, so let's go back to my grandmother, right? So let's put